Mr. Taylor, we propose to hear argument on your application to adduce fresh evidence from both sides, and then we'll consider what we think of that, and then we'll go on from there.
Lady, could I introduce counsel? I'm here on behalf of the appellant, Warrington Phillip, with my learned friends, Miss Jessica Jones and Miss Amanda Clift Matthews, both of the Bar of England and Wales, and Miss Taliba Byron of the Bar of St Kitts and Nevis. The respondents are represented by my learned friends, Mr Dane Hamilton of Queen's Counsel and Mr Valston Graham, the Director of Public Prosecutions of St Kitts and Nevis, both of the St Kitts and Nevis Bar. My lady, my lords, could I apologise at this stage for a number of matters? The first is the late notification of the fresh evidence ground, which was served with our case in December. The details of the difficulties and the background to that are set out in our supplementary case, and which also responds to the respondent's case. And a further apology for the late service of the further supplementary case and additional affidavits of the appellant and Elena Phillips. My lady and my lords, the intention behind the service of these documents was to assist the board. I accept that it is regrettable and I apologise for the lateness of it. But could I put it in this context, is that the supplementary case simply responded to the respondent's case, and the further supplementary case sought to deal with an issue raised by the respondents that Elena Phillips hadn't pursued the matter of her proposed fresh evidence with the trial lawyer. And it also dealt with the affidavit of the appellant in regard to the bad character matter. Well, it also dealt with the response of Dr. Brown, the trial lawyer, which was only received on Monday. So I say that because I do wish to apologise to the board. I've apologised to the respondents, and those are the circumstances in which these matters arose.
It's the respondent who really requires your apology rather than the board. The board can cope with anything, but the respondent may have things to do.
My lady, yes.
Anyway,
I have apologised.
We've heard you say that.
Profusely.
Let's get on.
My lady, in terms of the fresh evidence matter, can I put it in this context that the prosecution case was that this identification evidence in effect placed the appellant at the scene with no innocent explanation. But even on the prosecution case, we say that the police procedures in obtaining the forensic evidence were wholly inadequate, particularly because of the failure to implement recognised safeguards, and that this led to potentially unreliable test results, and that the fresh evidence identifies other additional fundamental flaws and demonstrates the high risk that the results were tainted by cross-contamination. My lady, my lords, the ground is set out in the appellant's case at page 1042, paragraph 20. This it undermines the central plank of the prosecution case, and the fresh evidence in summary is the appellant's sisters, Elena Phillips, serving police officer of 20 years, Bonalyn Philip James, were both present at the hospital when Corporal Keynes attended, and the effect of their evidence is that there's unprotected physical contact between Corporal Keynes and the appellant, and that Keynes had blood, what's presumed to be the deceased blood, on his clothing at that point. Dr. Syndicum Court sets out her opinion on the likelihood of the cross-contamination of the DNA samples based on two bases. The first is that on the prosecution evidence at trial, including the possible inferences from the evidence about physical contact. And secondly, on the additional scenarios described by the appellant Elena and Bonnelin. My lords, at page 1043 to 1046, paragraphs 25 to 37, if I can summarise the prosecution evidence on this issue. Corporal Keynes, the officer in the case, arrived at the murder scene, donned protective gear of some sort, and there's a dispute on the prosecution evidence as to what that consisted of, helped move the deceased body out of the car, and it's a description of a brutal killing, the aftermath of a brutal killing with a huge amount of blood, removed his protective clothing, and travelled in the same police vehicle as the deceased body to the hospital. It's unclear on the evidence where he sat or where the body was.
Did he say that he went in the same car? He did.
The evidence comes from him.
Yeah.
The evidence as to where he sat is unclear. It was described as a two-door vehicle pickup, which was open at the back. And I can give my lords the reference. It's page 611, lines 7 to 8. That the body was placed on the pickup truck, page 278, line 10, and Keynes travelled with one other officer, page 602, line 16, and 605, line 9. Bonnelin's statement is that Keynes was in the back with the deceased body, and she goes on to say that the suggestion is that he assisted, or one can infer that he assisted move the body from the truck to the morgue.
So her case is, or her evidence is that he was in the open part of the pickup.
That would seem to be. She says that he was in the back with the deceased body. Well, can I take your lady, my lord, to the her statement? It's at page 1105.
1107, this bit, yes.
Paragraph 9 at page 1107. She heard someone say, so they have the body in a pickup truck. I don't know who said it. I looked, I saw there was a body beside Keynes in the pickup truck covered with a sheet. Keynes was sitting upright at the back of the truck, and the body was lying next to him. It does suggest that he was in the back of the open back of the pickup truck, but it's not clear.
And there's some evidence somewhere that it was an open pickup. I mean, it's the picture I've got, which may be wrong, and that's why I ask about it. It's a pickup. It's got presumably a cab with 2 or 3 seats at the front and an open back.
We don't know how many seats there are, but we do know it was described at page 611, lines 7 to 8, as a pickup, 2-door vehicle, open at the back.
Yeah. Thank you very much.
Continuing the narrative, Keynes saw the appellant at the hospital, and this is all on the prosecution's case, looked at the appellant's injuries, seized a T-shirt from him and arrested him, escorted him out into a police vehicle, but then denied that there was any physical contact between them at all.
Sorry, where are you reading now?
My lord, sorry, I'm summarising the case, but it's set...
I'm sorry, I was still on the affidavit of...
Oh, I'm so sorry. I'm summarising paragraphs 34 to 36, and I'm currently on paragraph 36
of your case.
My case.
Your case. Yeah, thank you.
And when she says at 1107 that the body was fully covered, do we know if it was in a body bag or
a sheet?
What?
It's described as a sheet.
Plastic sheet.
Yes.
It was if I recall, it was wrapped in a plastic sheet.
My lord, yes, that's the evidence. Thank you.
Well, that was the evidence at the trial, wasn't it?
That was the evidence.
Yes. Whether what she's saying is consistent with that or not is one of the things we may need to look at.
My lord, having left the hospital, At the police station, Corporal Kane says that he put on protective gloves. He took swabs from the appellant's hands. A DNA profile matching the deceased was found on both his right and left hand, and the probability of randomly selecting an unrelated individual matching this minor DNA profile was approximately 1 in 1.3 quadrillion. The deceased's DNA could not be excluded from a swab taken from his left hand, the probability being 1 in 9,200. My Lords, at paragraph 31 of my case on 1043, I set out that it's clear that the prosecution saw this, understandably, as incredibly powerful evidence. They describe it variously to the jury in their closing speech as incontrovertible proof that its DNA doesn't tell lies. And, my Lord, one additional reference, which isn't there at page 662, line 18, it is the most reliable thing that we have for the administration of justice. It's unanswerable. And in the face of the now fresh evidence, our submission is this would place a completely different picture before the jury. It is demonstrably controvertible, and there are answers providing an alternative and more likely innocent explanation. My lady, my lords, this was a case that was crying out for an expert to be instructed on behalf of the defence. And the position, although we haven't got a certain answer, the position is as follows. It's clear that the defence case challenged the DNA evidence. And we understand from Miss Taliba Byron that on her inquiries that funding would be available. We asked Dr. Brown why he did not obtain a report, and we haven't had a response to that query. And we asked the respondents to confirm whether an application was made to the judge and funding granted, but we understand the file cannot be found. Our submission is it would be extremely unlikely that such a report was obtained. Dr. Brown said during his closing speech at page 456, line 18, we don't have any scientists on our side. And in his closing speech at 750, line 8, he laments saying, it is a sorry day when you have all the chips on your side and you come to give evidence for people who pay you, he's referring to Dr. Noppinger, and the other side doesn't have the benefit of that. There's no local DNA expert in St. Kitts, so any application would have been for an expert in America. And there's no suggestion that the respondents or Mr. Noppinger were approached by another expert seeking the test file. My lady and my lords, in light of the other matters which we rely on in terms of the poor representation, poor level of representation by Dr. Brown, we would suggest that this matter was simply not pursued. It is also probable that Dr. Brown didn't obtain a report because he didn't see that the evidence was problematic, although he did challenge it, because in closing, at page 713, line 4, he describes the forensic evidence as the weediest part of the case. And at 7433, there is no forensic evidence which ties this client to the crime scene. My lady and my lords, in those circumstances, whilst we don't have a definitive answer, I would ask the board to approach this on the basis that the most likely situation is that no report was obtained on behalf of the defence at trial. In terms of the fresh evidence, our initial submission is this is clearly fresh. It was something that was not before the jury. It was not called at trial, and in fact it takes the defence case far beyond the matters which Dr. Brown raised with the witnesses and the answers that were given. My lady, my lords, at page 1043 of my case, at paragraph 29, I set out there that the essence of the defence case on this was that the results of the DNA were not conclusive of the fact that this was a deceased DNA. And respectful submission to, with respect to Mr. Brown, Dr. Brown, it seems that the jury, in light of the ratios, were going to spend very much time on that proposition. And the second is that there may have been contamination of the swabs taken from the appellant. My lady, my lords, we've sought quite extensively the original test file from Mr. Noppinger, so that the test can be verified and the results. Unfortunately, the respondents haven't been able to assist. The file is with the DNA laboratory in America, and they are asking for a court order and a fee to release it. But we don't pursue any criticism as a result of that. We can't as the test results, and therefore the question is whether there's an alternative innocent explanation. In terms of the evidence of Mr. Noppinger regarding cross-contamination, and I'm looking at this is a summary of the matters at paragraphs 38 to 44 of my case at page 1046. The matter was raised as an issue, but it was in an extremely narrow context. Firstly, the questions were theoretical and they were abstract. No particular evidential-based scenarios were put to Mr. Noppinger to comment upon. The dangers of the cross-contamination and the particular failings, even on the police case, on the prosecution case, were not raised specifically with Mr. Noppinger to identify the risks of contamination that would be involved. And secondly, even the answers that were given were of very limited assistance. There was an attack, a potential attack on the procedures in the laboratory and whether opening two files at the same time could cause contamination, and that was rejected. And there was a question to Mr. Noppinger as to whether he could comment on the collection of the samples at the point in St. Kitts, and he said, no, I just wasn't there. So taken at its highest, Mr. Noppinger's evidence on this is that he may have spotted contamination if he found another person's profile in the samples he tested. And of course, that was irrelevant. There was no suggestion of that here. And that someone with DNA on his hands at the collection point could simply pass it on by holding their hands. And of course, we say the risks and the dangers of cross-contamination go way beyond that. The jury clearly recognised that this was an issue, and page 1046 of my case, paragraph 41, I set out the two questions that they asked. How does DNA get from one person to another? And how long would it last during normal washing? Well, in terms of transfer, the answer was sneezing, saliva, grabbing, scratching, or by touch. And in terms of the washing, well, we know the evidence was that the appellant had a shower that day anyway on his return home, and therefore that really wasn't an issue, and it was a 3-month period that was suggested. So it's not really a relevant consideration. The only potential scenario that was put, and this is not based on actual evidence, was paragraph 42, 1047 of my case, is defence counsel said, DNA material from a victim can be attached to your person given circumstances, even through you were not present at the crime scene at any time. I go to the crime scene, I touch the car, I touch the body, I come, I speak to you, and I touch you. The DNA could possibly be transferred partially. Mr. Noppinger's answer, with respect, really didn't take the matter much further. the actual wording, there's an error in my case, I'm sorry, is if I can explain, touching an object, you call that primary transfer, the secondary of me touching another person is a lot less. Well, in the context of the case, I would respectfully submit that that's simply meaningless. Defence counsel also raised the question tentatively with Corporal Keynes, what does cross-examination mean? One person to another, and that matter wasn't pursued. And that was the extent of the investigation of this issue at trial. The point of the summing up, the jury were left with the following conclusions. The only methods of transfer that they were told about were holding someone's hand, sneezing, saliva, grabbing, scratching, or by touch. Transfer by sneezing and saliva, in this case, could only realistically be from the deceased as primary transfer, and that was ruled out. And there was no evidence upon which they could accept any of the others were possibilities. And in terms of holding someone's hand, that was the extent of the physical contact, or by touch. Well, they were met with the answer from Keynes, who said, one, I was wearing protective gear at the scene when I moved the body, and two, that when I didn't have any physical contact with the appellant at the hospital, and three is that when I took the DNA sample, I was wearing gloves. It's right that the issue was before the jury that Keynes himself said, I travelled in the car with the vehicle with the deceased. But as my lord pointed out, that she was wrapped in a sheet at that time. And that matter just was not put to Noppinger. It wasn't explored with Keynes where he was sitting, how near, and it wasn't investigated further. So the state of the evidence at the end of the trial really fails to deal with any of the potential dangers that are now identified. The cellular material in unprotected hair, in shoes, on skin, how the protective gear was disposed of. Mr. Noppinger, even at one point when Dr. Brown was cross-examining him in relation to the laboratory and the possibility of cross-contamination with different cases, said DNA doesn't fly through the air. Well, that was in a wholly different context in terms of the laboratory, but if the jury were to take anything from it, the restriction as to what was the potential methods of transfer would be those that were outlined, direct physical contact. So an entire area of the danger and the risks of cross-contamination was simply not put before the jury.
Until the fresh evidence became available, and I absolutely understand the difficulties of doing it remotely, and no doubt pro bono, but until the fresh evidence became available, was there any proposed ground of appeal relating to the question of contamination?
My lord, the original grounds related, I think I can answer it in this way, the only ground that related to the DNA evidence was the judge's summing up and the adequacy of it. There was no...
Which is now abandoned.
Which is now abandoned.
So there wasn't any complaint about any of the matters that you've just been telling us about, namely the adequacy of the investigation of contamination on the case as it was at the trial.
My lord, I think
that's right, isn't
yes.
it? You've added that in now that you've got the fresh evidence, but the fresh evidence isn't directed to the state of the evidence at the trial. It's directed to asserting an entirely different and much advanced risk of contamination.
My lord, could I deal with it in this way? That was clearly a huge concern when we were promoting this ground. And the reason that Dr. Syndicum Court was asked about 3 scenarios was to deal with the potential stance of the board, if I can put it in that way, that you reject the evidence of Bonalyn and Elena. And then what the board is left with is the material that was available at trial.
I understand that.
My lord, I apologise, but Dr. Syndicum Court dealt with, as one of the scenarios, on the prosecution case evidence alone, excluding the
I know
fresh
she did.
evidence.
What I was concerned to establish was whether there was any complaint about the approach to contamination at the trial until you had the fresh evidence of the two women. And the answer is no.
My lord, the answer is no. I think it's right to say that the fresh evidence triggered the inquiry.
Yep.
Can you guys help me with the sequence of events? Because your solicitors were first instructed to act pro bono, one has to keep that in mind, in November 2013. Then nothing seems to have happened until January 2015. I'm looking at the page 1141 of the bundle, the affirmation of Amy Kwan.
My lord, we have prepared a very detailed chronology, which I can, of course...
May not be necessary. I mean, maybe a simple question. Then in top of the next page, January 2015, Ellie James, who I think is the husband of Bonalyn,
My lord, yes.
raised the point about possible evidence, sisters, and then nothing seems to happen until August 2016.
Well, my lord, there are a number of issues at the outset in terms of obtaining the papers. I can say that initially. But the sequence is that the grounds having been lodged and leave granted on the original grounds, I was instructed as leading counsel, and it was at that point the discussion moved on to the question of fresh evidence.
Yeah.
My lord, I'm not sure if that answers.
You were instructed when
In May of last year.
when was permission granted? That was
March
March of last
year.
Yep.
Yeah.
Yep, I see. Okay, thank you. We now got a very detailed chronology.
Permission granted effectively on the bad character point.
My lord, yes.
Yeah.
Can I ask you about a matter of procedure, which it may be Mr. Hamilton will have to help us on this. But in St Kitts and Nevis, if an appeal has been refused, is it possible for a case to be referred back to the Court of Appeal, either by the governor, perhaps as a reference, or perhaps by some sort of review commission?
My lord, I know in some jurisdictions that's possible. Could I check with my junior? My lord, we know that in Jamaica it's possible to petition the Governor General, but we don't know the position in St Kitts.
Right.
Quite likely.
My lord, by the time of the defence closing speech, the contamination issue had effectively fallen away. The emphasis at that stage was on the ambiguous nature of the samples and the test results. The prosecution counsel in his closing speech said that Kane's answers, protection, no physical contact, and this is at page 678 of the record, destroyed any suggestion that there could have been any form of contamination. He later told the jury that there was no contamination in issue and they should not be sidetracked by it. And that's at 684 and 685 and 690. In terms of the judge, unsurprisingly, doesn't take the matter further in the summing up. My lady, my lords, the nature of the fresh evidence, and I'm now at page 1048, paragraph 51 of my case, is that scenario one is even on the prosecution case at trial, the opportunities for cross-contamination were manifest. The second limb of that submission is that even though Keynes denied physical contact with the applicant at the appellant at the hospital, the circumstances suggest that this was extremely unlikely. He said that he looked at the appellant's hands to identify the wounds. He took possession of the appellant's shirt, arrested him and escorted him out. Now, it at least raises the possibility that there were direct contact in those circumstances, either accidental or otherwise. My Lords, at page 48, paragraph 52C, you'll see that there were, these criticisms are set against the background of extremely weak safeguards and procedures in terms of the evidence available at trial. My lady and my lords, could I take you briefly to the evidence of Dr. Sinderkin Court, just the conclusions at page 1121. Paragraph 4.7, the scenario is, how likely is it that the DNA found on the appellant's hands was transferred there between his arrival at the hospital and the time that the swabs were taken in the police station? And 4.7.1, highly possible, even though she says they were reported to wear protective clothing. Even on the account of Keynes at trial, he wore protective clothing at the crime scene. He removed when he was travelling with the body. There remains a risk of transfer for the deceased DNA to Mr. Phillip through other adventitious contacts described below. Then goes on to talk about not being 4.7.2, third line down. It would be very difficult to be completely sure that no blood or other sexual materials transferred to unprotected clothing, face or hair or shoes, and highly likely that at that point non-protected parts had some cellular material from the victim present.
Just hang on a minute, Mr. Taylor. When we're at 1121, 4.7, is the question being asked at 4.7 on the basis of the evidence at trial or on the basis of all the evidence that she's now got?
What?
I grant you that the second line of the answer helps you because it says that there is a risk even on his account at trial. But she's not, is she, being asked to distinguish between the supposition that the evidence, the right case is as per at trial, and the rather colourful evidence which we now have.
Yeah.
It's certainly been pleaded on the basis that she's commenting on the prosecution case. Could I just check, because there are a number of other matters in the report which would...
Yes, of course. I mean, that's why I asked.
Yeah. At 1113, she says that she's been asked to consider the following scenarios and comment on the possibility of contamination. And the first is Officer Keynes's account, but the then goes on to include the accounts from the new witnesses.
Yeah.
And then, my lords, at 5.2 on page 1124, in this case, there appears to be low-level risks in association with transfer from past events or within the laboratory. Multiple levels of high risk of transfer associated with actions around the crime scene and subsequent activity, even on the account given by Keynes, increased on the factors set out by Elena and Bundlin in their statement.
No, what I was trying to find out was whether she'd actually anywhere addressed the two, as it were, in watertight compartments, and she's done it in a slightly different way. Yeah. All right.
I mean, it's perhaps clearest, 1113, just below figure 3, the heading 3, examination of evidence, she says, the intention of this section is to summarise the relevant evidence as a preamble to discussion of possible routes for contamination. And then she goes on to include amongst the evidence 3.5, the account now given by Ms. Phillip, 3.6, the account given now by Ms. James.
Yep.
My Lord, yes, and at 1122 at 4.7.2, contact with the victim, it's considered in the context of Mr. Kane's wearing protective gear, as he said. Mm. Lady, my Lord, I'm so sorry. Could I just take a moment just to check that there's...
You see, you get to... She's in a difficult position, but you see the way she deals with it at 478, the bottom of 122, 1122, because, as she says, she's got a contrast in evidence. Yeah.
Sorry, could I just take a moment to...
I mean, we'll see what is said against you, but it may be that if there is potentially reliable evidence that the chap arrived at the police station dripping in blood and then put his hands on the defendant, you might not have a very Herculean task to establish that that created a plain risk of contamination that wasn't considered at the trial, if you've got potentially reliable evidence of it.
My Lord, indeed, but can I answer it comment on this in this way, is that even on the prosecution case, there are so many matters that weren't before the jury and the dangers and the risks involved there, that the same concerns would apply in terms of whether it would have made a difference. I see. So I just wanted to, if I could just take one moment to... Yes, thank you. Can I just deal with one point in my my learned friend's case? He raises at paragraph 87 of his case that one has to look at the concerns raised by Dr. Syndicum Court about safeguards in the context of limited resources. Can I make two comments on that? One is, this is not just a case of lack of resources, but the absence of proper safeguarding procedures. No written records, no management of the scene, and other factors. No notes of which officers were involved. But in terms of protective gear, my submission is this, is that if the state is planning to rely on DNA evidence, it must put into place appropriate safeguards. The risks of results being tainted are identified as being so great that it's simply not a question of it being a luxury. If it's to be relied on for a conviction, then there must be appropriate safeguards to ensure that the integrity remains. My Lady, my Lords, in terms of page 1049, paragraph 53 of my case, Elena and Bonalin's statements, our submission is it supports the following propositions, if found to be credible. Keynes was likely to have had unprotected contact with the deceased in the police vehicle. He was then had unprotected direct physical contact with the appellant before taking the swabs. And in addition, the appellant was said to have travelled in the same vehicle that had just brought the deceased body to the hospital. Paragraph 54 at 1050, Dr. Syndicum Court's report raises the level to this, that the risk of secondary transfer is not only quite possible, but probably the norm if effective actions are not taken. And that, again, that statement is not reliant on the evidence of Elena and Bonalin. The risk is higher in environments where people may also be sweating. paragraph 4.2 of her report, and it appears that none of the effective actions normally expected to be taken to protect the integrity of the forensic evidence were taken in this case. And her conclusion puts it that it's highly possible that the DNA was transferred to the appellant's hands before his arrival, and concludes at page 1123, paragraph 4.7.11, considerable doubts about the security of the prosecution assertion that a jury could be sure that the finding was linked to him with direct contact that evening. My lady, my lords, in terms of the legal framework for the admission of this evidence, it's clear that in my submission the overriding test is it in the interests of justice to do so?
Well, the first question is whether it's apparently credible, isn't it?
Well, my lord, yes, I'm just taking it in terms of the sections.
Oh, all right.
I'm so sorry. In section 48 of the Eastern Caribbean Supreme Court Act, the first question is whether it's in the interest of justice. The next question is whether it provides a ground for allowing the appeal, and then credibility and admissibility. Paragraph 1050, page 1052, paragraph 61. In terms of allowing the appeal, this evidence would have painted a wholly different landscape before the jury. One of the central planks of the prosecution case would now have to be seen in terms of high risk and high dangers of being unreliable. These were not matters that were before the jury. They may have been aware of some of the issues, but the consequence of those issues was simply not before them, and it's not a matter which would be within the jury's knowledge. Page 1054, paragraph 66, we put it in this way, is the fresh evidence would move the prosecution case from a confident assertion there was no innocent explanation for the DNA test results, and that the chances of the DNA found on the appellant's hand belonging to someone other than the deceased was 1 in .1 quadrillion. That's what happened at trial. The fresh evidence moves it to a level at which there are serious doubts about the integrity of the samples taken, and therefore the reliability of the prosecution assertion. In terms of credibility, clearly doesn't in my submission apply to Dr. Syndicum Court. In terms of the appellant, Elena and Bonalin, we would make these submissions, and this is paragraph 67 onwards at page 1055 of my case. There are undoubted inconsistencies in the evidence. My learned friend has addressed some of them in his case. That's accepted. But we would ask the court to consider those inconsistencies and the impact on the question of credibility in this context. Firstly, each is being asked to recollect incidents from some years ago. Secondly, there's a particular fact relating to the appellant which may explain some of the inconsistencies, in that he was, on his account, and it's based on the evidence from the trial, he was waking up after having been given an injection of Valium some time earlier. Thirdly, the alleged failings now put forward in the safeguards and procedures do not stand in isolation. They must be, in our submission, set against the many proven flaws that were apparent at the trial, in Keynes's evidence and the investigation procedures generally. The jury, in judging credibility, we would submit this is a matter that the board should respectfully take into account. In judging credibility, they would look at the denials of Keynes that in circumstances which really suggest extremely strongly that there was physical contact, that if he was lying about that, then the other evidence may also be credible about him being having blood and travelling in the car. It's supported, this evidence is supported by the prosecution case in parts. It's accepted by Mr. Keynes that both sisters were at the hospital at the relevant time. Bonnelin's account relating to Keynes arriving in the same vehicle as the deceased is accepted by Keynes. But crucially, there is a solid area of consistency between their accounts on the central issue of Keynes being bloodstained and his physical contact that he had with the appellant at the hospital. My lady and my lords, if I could take you, and I hope to do this relatively briefly, but I think it's important to see the detail. In terms of the proposition that in the cubicle, Elena admonished Keynes for touching the appellant whilst he had blood on him, that's covered by both the appellant at page 1093, at paragraph 19, as soon as Officer Keynes put his hands on me, my sister walked in and saw him. She said, "Keynes, what are you doing putting my hands on your brother? You know where you're coming from and you have blood on you." Elena, at page 1102, at paragraph 19, Keynes called out Warrington's name to try and wake him and then shook Warrington's hands and patted his legs. Warrington responded very faintly with a few sounds, and I told Keynes, "You can't touch my brother, you're full of blood." In terms of Elena warning Mr. Keynes about the presence of blood on his clothing in the waiting room, if I can take your lordship, my lady, my lords, to paragraph 11 of Elena's statement, paragraph 16 of Elena's statement. Keynes in the waiting room, 6 lines down, saw blood on his hands. I told him he was covered in blood and he looked down and said, "Oh, I hadn't realised." And then Bonnelin at 1107, paragraph 11, standing in the waiting area, a sister pointed out to Keynes that his shirt and his hand had blood on them. And then physical contact between Keynes and the appellant on arrest. Bonnelin, again, paragraph 12 of that page, that Keynes and Mitchell will bring Warrington outside handcuffed behind his back. Keynes was holding Warrington by the elbow. Elena at page 1103, paragraph 23, Sergeant Keynes was holding Warrington by the hands. And then finally the appellant at 1094, paragraph 20. Officer Keynes was holding both of my hands with his hands and told me we have some questions to ask him, put some handcuffs on my hands. So in light of those factors, we would submit that there's nothing that would cause the board to conclude that these are matters which are obviously unworthy of belief, which is, in our submission, the test as set out in Benedetto. The board may, of course, consider that the most appropriate disposal of this matter in light of that is to quash the conviction and remit the matter to the Court of Appeal to hear the proposed evidence and, if necessary, from Dr. Brown.
Well, you wouldn't quash the conviction first, would you? Because there'd be nothing left to remit. But, yes, okay.
Finally, page 1055, paragraph 70, reasonable explanation. Our submission is that there is a reasonable explanation in that these matters were raised with Dr. Brown, certainly Elena and the appellant, that he failed to pursue them. He failed to obtain an expert's report on the facts that we have, and even though this was a live issue at trial, and there couldn't have been any disadvantage in any disadvantage in pursuing these matters. This was not a case where there's a deliberate decision not to advance particular defence before the jury. The issue was there. In terms of Dr. Brown's report, my lady and my lords, I don't know how much you want me to deal with his responses. I'm very happy to do so. But
well, we've got the material in your submission.
Well, you've given a supplementary affidavit from the appellant on that matter, so we know his position.
It's clearly disputed, and all we would say is that it's an inadequate response. It doesn't deal with the issues, and the concern that's raised is that he considers that it is an acceptable explanation to put forward to this board that despite an admission of guilt, he ran the trial which was clearly in opposition to that in his speech to the jury. So, my lady and my lords, in terms of Dr. Brown's input on this, I would ask you to accept that this is analogous to a case where there is no effective response. The matters have been raised, and therefore it should be investigated further.
Where do you say, you've just used the expression admission of guilt?
Well, my lord, in his...
Just tell me on which of his responses you're basing that on. Is it 32 of the further supplemental case?
My lord, it's... I've set it out in the actual supplementary case at page 5.
Thank you.
And the original emails are there behind it, but they're set out verbatim there.
Yes.
Further given his admissions instructions to me. And then he, at the paragraph 10, Mr. Phillip's graphic description to me as to his involvement in this matter in my bosom.
Yes.
And that, of course, is in the context of no notes that we've been sent, memorandum or witness statement, and the matters set out at page 7 of
Sorry, forgive me, Mr. Phillip. To which document are you referring?
I'm so sorry.
I have from you your case and a supplementary case.
My lady, yes, in the further supplementary case.
I haven't got the further supplementary case.
Oh, well, you need that.
Very, very sorry, but I understood they'd been served yesterday.
There's one that I got this morning for the first time, which is
That
called...
was an affidavit, was it?
something called a further supplementary case.
Yes, the further supplementary case is what contains Dr. Brown's responses, so it's important.
My lord, yes.
I mean, one of the difficulties in the case, of course, is that although your solicitors have written in, if I may say so, perfectly proper terms to Dr. Brown, one of the things that there hasn't been time to do, because it's all so late, is that the Crown hasn't had a chance to take a proper statement from Dr. Brown dealing with all the questions. But there we are. It's just one of those things. But we do need to have all of us in front of us the three principal responses, which are in your further supplementary case.
My lord, yes. My lady, could I just summarise the matters there at page 4 and 5? Following
Right, I've read them now.
I'm grateful, thank you.
Anyway, I mean, what I don't quite understand is Elena, who is obviously an experienced police officer, and apparently, on her present evidence, appreciated right from the outset the dangers of contamination if the police officer had blood on his hands, doesn't then pursue it. I mean, all she says is that she saw Dr. Brown a week later and mentioned these things to her, but Well, once the prosecution had produced their report of their expert and were clearly relying heavily on DNA, are we to believe that Elena didn't even realise the significance of her evidence? I mean, she doesn't deal with that at all, does she?
In the further supplementary case, one of the reasons for her further affidavit is at page 21, is she deals with those points.
Right, well, not very much. She does says that she thought he was a lawyer and she was a police officer. But I mean,
This is a major problem, Mr. Taylor, isn't it? You've got a case which is dependent on, admittedly, three independent strands, one of which is DNA. You've got a trial at which the answer to the DNA, which is being postulated, whether well or badly, is contamination. Yes? You've got a police sergeant who says that the investigating officer arrived in the hospital dripping in blood and then made physical contact with the defendant. You've got another woman who says she saw the same, and indeed that they went off in the same car, in the same vehicle together to the police station. Neither of them says a word at the time, and not only not at the time, but when the trial is in November 2008, the conviction is not accepted, there's an appeal, that's heard nearly 4 years later in 2012, still neither of them has said a thing. And the first appearance of these important allegations, which, as you say, if they're right, make a huge difference to the case, is a month before, is not even when the appeal is being launched to the Privy Council, but years after it's been launched and after on different grounds and permissions being given, and it all arrives a month before the hearing.
My Lord.
Why, you have to confront, I think, the real difficulty that on the face of it, it might be said that it's simply not credible.
My Lord, can I respond in this way? Is that if this was material which contradicted all of the known evidence at trial, so if the scenario was that extreme caution was taken by the police in the gathering of evidence, the safeguards in avoiding cross-contamination, then it may be said that the allegations being made now are simply wholly untenable because they're so very different to what was understood to be proven at trial. My Lord, in considering the credibility of these allegations, our submission is it must be looked at in the context of what was there in trial. I don't say it in this way that it's simply more of the same, but it's certainly not wholly different to what was accepted as serious failings at the trial. And in terms of judging its credibility, my lady and my lords may think that the jury would have seen it as a very short step from rejecting Mr. Keynes's denials of physical contact, particularly if they'd been properly investigated by defence counsel, to finding that he may well have behaved in this way, and so they couldn't be sure that there was no cross-contamination. My Lord, can I also say this, and it's a point I apologise for repeating, but I think it is crucial, is that notwithstanding the evidence of Elena and Bonolin, Dr. Syndicum's court's evidence raises such profound concerns about the investigation and the safety of the test results that standing alone, it demolishes the safety of the conviction.
Right. and have I got this right as well? If this material is right, it follows, does it, not only that they've said not a word or very little over all this period, despite the fact that contamination was the issue, but also that counsel, who is running contamination and has been told that the policeman arrived at the hospital covered in blood, doesn't adduce that evidence. Is that right?
Lord, can I?
For some reason or other, doesn't adduce it. Now, it wouldn't have been evidence, I mean, just supposing that you're right in reading his most recent email as indicating that he'd had some kind of admission to the offence, as distinct from some admission to something else, supposing it's an admission to the offence, it wouldn't inhibit him in calling Elena, would it?
My Lord, I think it depends how it was done and how if it followed on from that. I mean, my Lord, can I address it in this way?
How could it possibly, even supposing the defendant had made a full-blown admission that he'd killed his wife, what is to stop counsel adducing the evidence which goes to show that at least one strand of the Crown case is based on a false premise, namely proving the contamination? Not only is there no inhibition to it, it's your positive duty to do it.
My Lord, can I rephrase my answer? My concern stems from the way it would be dealt with in the closing speech. And the reason I say that is that if, as it was here, an assertion of innocence is made based on that evidence, that would be problematic.
Well, that would be problematic, but well, I say, all right, that's the answer you say.
My Lord, the difficulty here is that we say that the level of representation by Dr. Brown was so flawed and so inadequate that to try and understand why, if he had this evidence, he didn't call it, simply doesn't call for a rational response.
I see.
My difficulty with that is that the appellant employed Dr. Brown to conduct the appeal. Dr. Brown raised a question concerning the DNA evidence on appeal, namely the judge's direction. And Elena's explanation in her supplementary affidavit for not raising the matter on appeal is simply this: I did not raise the matters again during my brother's appeal, as Dr. Brown was still the lawyer. Is that a credible position for her to take, given her evidence of a blood-stained policeman touching the accused, and her knowledge in her own affidavit of the danger of cross-contamination?
My Lord, I would simply respond that these are factors which, if Elena was now called to go before the jury, that they would have to consider, but that the credibility in terms of the core evidence of blood and the contact would not be diminished to the extent that it can be described as not credible.
Thank you.
Well, Mr. Taylor, you've spent more than an hour on this application, for which we're very grateful, but we do need to hear from the other side about it, unless there's anything further you'd like to say.
My Lord, there's nothing else. I'm grateful to Ms. Jones. Just one piece of information in relation to the chronology of how these things came about. In February 2015, that was when Ellie James told us about Elena's potential evidence. We then sought a waiver of privilege in March 2015, which was received in May, and Dr. Brown was contacted straight away and the matter was put to him. So it's been an issue as to why he didn't call it from that time period.
With him rather than with the Crown, but yes, with him certainly, yep.
My lady, my lords, unless I can assist you any further.
Thank you very much, Mr. Taylor. Mr. Hamilton.
Actually from the island of Antigua and Barbuda. I'm here with the Director of Public Prosecutions, Mr. Graham, and our solicitor. My lady, I think the appropriate place for us to start from is the legal framework under which we would try to admit this evidence.
Well, it's sections 48 and 49, isn't it?
Section 48 and 49.
Yes. Well, we've looked at those.
And I do concede that the court has a discretion as to whether to admit this evidence or not. But before we get to the discretion, I would suggest that the evidence must first be credited. And it ought to be fresh. I put it that way. Although the court does have a discretion to admit, even though it is not fresh, but it is credited. The second point I want to make, my lady, stems from the case of Poor against Queen. I believe that is in volume
3.
Volume 3.
1886.
Oh, thank you.
What is clear from the learning there is that 35, 36, that the court have to proceed very rarely with affidavits that comes from the appellant years later, and close relatives of the appellant, if I may suggest that. Which are not fresh. And whose credibility one can seriously question. I would just direct the court to paragraph 49 in relation to that issue of the Poor case of the judgment. And I would suggest to this court, I would submit to the court that both Bonalyn and Eilina has an interest to serve in advancing the appeal of the appellant. And the second point is that I would call it the Professor Good Johnson's point, where Good Johnson, his evidence was rejected because it was based substantially on affidavits supplied to him by the appellant. And those affidavits that were not admissible. I would humbly suggest, submit, my lady, my lords, that when one looks at the report, and I would hardly quarrel too much with the report of the appellant's expert, Ms. Denise Syndicum Court. The report is tainted by the affidavit evidence, the so-called fresh evidence of Eilina and Bonalyn, Eilina, Phillip, and Bonalyn. It is impossible for us to draw a very secure line between what was said, what Bonalyn and Eilina view of what occurred, which is the so-called fresh evidence, and the actual evidence which was led in the case, because she evidently took into account the evidence that was led in the case and Bonalin and Lena's evidence. And in that respect, the evidence is tainted. It's unreliable, if I may suggest. So she could not escape from the view that Corporal Keynes was covered in blood, or as you put it, was dripping blood when he entered into the hospital. That of course was denied. And he was challenged in cross-examination on that issue as to whether there was blood in him. And he of course denied it. And counsel did put it to him in a very strenuous manner. Now, those are the two important legal considerations that I submit. And on the issue of credibility, when one looks at Eilena's affidavit, one is driven rather ineluctably to the conclusion that her affidavit is, the statements she made in that affidavit are really designed to support the appellant's present claim of contamination. In the first place, she stated that, and you can find her affidavit, Lord, that in the appellant's case here, for ease of reference, at tab. Let me just get it. I have so many pieces of paper.
It's B. It's 1099.
109.
1099. Elena's affidavit.
Yeah. Yes, I have it. When she is recounting the events of the 16th of February, 2007, this is at paragraph 5, 6, and 7, and she stated, I came home from work in a taxi driven by Dinsdale Pemberton. Then she goes down to paragraph 8. I arrived home shortly after 7 p.m. I cannot remember what time I left work. My mother, stepfather, and sister Bonnet and James were at home. But we know that Dinsdale Pemberton gave evidence and was cross-examined. And he was very specific. He said, I arrived at that house at 8:25 p.m. 8:25 p.m. And it was then, about 5 minutes later, the appellant arrived in a car. And this is in fact supported in part by the affidavit of Bonnie Phillip, which is by Eilena. She said, I saw Warrington in his red pickup truck driving towards the house. Dale reversed the taxi so that Warrington couldn't park his car in the garage. Dale saw Warrington. Warrington parked the car in the garage. And as I was talking to Dale in the passenger seat of the taxi, I noticed Warrington walking. The crucial point is this. Eileen is seeking to put the appellant home at a time, at the crucial point in time when the time that the prosecution alleged that the murder was committed. Now, the prosecution timeline is that the murder was committed sometime between 7:15 p.m. and 7:45 p.m. Her sister Bonalyn never arrived home until 9:15. But in paragraph 8, she said, I arrived home shortly after 7 p.m. My mother, stepfather, and sister Bonalyn, Phillip James, were at home. Bonalyn, on the other hand, and my learned friend dismisses it as little inconsistencies, said that she arrived home 9:15. She finished work at 9 o'clock. So you have to ask why. And my suggestion is the why must be answered with the need to put Warrington at his home shortly after 7 p.m. The material time that the prosecution was alleging that the murder took place. There are a number of inconsistencies in relation to the hospital, what happened at the hospital in this account. But quite clearly, this is evidence in my submission, assuming it was credible evidence, which could have been led at the trial. The point is made that Eileen is a sergeant of police. She had worked in the CID for 5.5 years. She was familiar with evidence collection. She claimed that she was at court and that she gave instructions to counsel. And we have to seriously ask ourselves, well, her brother got convicted at the trial. Would the family have persisted with a lawyer who had ignored the instructions given by the appellant and his witnesses? Is that credible? No. Kane's evidence is that he never, at any point in time, on the 17th, touched the appellant until he took swabs from him of his fingernail and his fingers, and that was late in the morning. I believe more than likely in the morning, it would have been the 18th, the 17th, 18th. Kane's view said that when he arrived at the hospital, the appellant was lying on his stomach. He spoke to him, and my lords, I will find and I will locate that as part of the evidence to you. But what Keynes was really saying is that
504 and 5.
504, yes. When he spoke to him, the appellant gave him explanations which were in line with the interview he gave on the 17th, on the 18th. He was not woozy. He turned over, he asked him some questions, and the explanations that he gave are very little, show very little difference between his written interview at the police station. I'd get that for you, my lord. Yes. Reviewed. But his sister, of course, said that he had to be led outside, a fresh evidence affidavit. He had to be led outside. He was woozy. They had to hold him up. She tell us things like we had to. I went in there and I checked him from head. I check him thoroughly to see if there was any blood and anything on him. I tried waking him. I couldn't wake him. But a short while later, Keynes came and shook him, and he was, is that credible? But at page 505 to 507, top of the page, Keynes told the court that he was in the emergency ward, my lady. He was lying on his chest. Did you say anything to him? Yes, my lady, I spoke to him, my lady. I told him I'm making an investigation into the murder of his wife, and I would like to ask him a few questions as to his whereabouts on the night in question, 16th February 2007. What did he tell you on the following page? He said he was playing golf up until 5:30. Specific time. That is in his interview. He went to Mango's at Jessup Bay, and from there he went to Tricia Williams' residence at Cotton Grove. Now, this is not a person who is suffering from sleep and from the bad news that his wife was killed, who had to be let out of the emergency room when arrested. Yeah, it's against this background that one must judge the credibility of Eilena's statement, fresh evidence statement. He goes on to say that he was playing golf until about 5:30 p.m. in the evening, and from there he went to Mango's at Jessup Bay. He left Cotton Grove and visited the water department, barbecue at Pump Road. Yes, he said he did not stay. He went down and turned around on the roundabout and went back to his residence at Jessup Village. Those are specific things that he's remembering. Those are specific elements of his defense that he's given to Officer Kane when first tasked about killing his wife at the hospital. So, without trespassing on your lordship's patience, I would say that my submission is that the evidence of Eilena certainly isn't credible. And I submit the same can be said about the evidence of Bonalyn, the fresh evidence of Bonalyn, that Keynes was in the back of the pickup when Keynes clearly stated that he traveled, although he traveled with the body, it was a pickup with two front seats, two seats in the front, two sets of seats in the front, and by then he had taken off his clothes. He said that when he arrived at the hospital, there were two other officers with him, Inspector Mike Mitchell and when he went in to speak to the appellant, both Mitchell and this other officer was with him. And that's what you'd see at page 5 and 9. Keynes never took the appellant to the police station. Keynes drove the appellant's red pickup, 1986, to the police station. The appellant was taken by other police from the hospital to the police station. Now, I made the point, and I won't push my luck, that Syndicom court's evidence relied heavily on the account given by Eilena, Phillips, and Bonalyn. And that can be seen quite easily, my lord. She said, the documents examined, this is at page 1112 of the appellant's case. Statement of Kevin Noppinger, affidavit Eilena Phillips, 26 November 2016. Statement of Bonalyn Phillips James, 29th of November 2016. At 1116, paragraph 3.5, Eilena Phillip, 3.6, Bonalyn Phillip. she considered. Phillip is sister of the appellant. She went to the hospital. Barnard James, sister of the appellant. This would have, in my submission, colored her view and reflected unwittingly in the conclusion she came to. She wasn't considering the evidence that was led at the trial in isolation. She was taking the now proposed evidence, the new proposed evidence of Bonalyn and Eileen into consideration in formulating her conclusions, which she expressed. On that page 1122, 4.7.8, and in my submission, the board should respectfully refuse to accede to the application of the appellant that this fresh evidence of Syndicum Court, Bonalyn and Eileen be admitted, including, of course, the appellant, and without a doubt, the appellant evidence ought not to be admitted. And I would make one further point. It was said that, and the point is, I put the point this way, the court did take into account the question of contamination. At volume 2 of the record, page 425, Dr. Brown's cross-examination, the question directed whether DNA material can easily be passed on secondarily. Dr. Noppinger answered him. Following page. From where you stand here, can you see that there was no contamination of biological material at the collection point? He said, I cannot. With DNA material on my hands at the collection point, I can simply pass it on somewhere or somebody else by holding the hands? Yes. So, Dr. Brown was alive to the issue of contamination. But clearly he had no instructions in my submission that the appellant was subsequently handled by Keynes at the hospital. At page 454, same bundle, 455, 454 and 455, Noppinger again deals with contamination. He talks about primary transfer and secondary transfer. If I touch an object, you call it primary transfer. The secondary of me touching another person is a lot less. So the jury heard that the possibility that there could be cross-contamination, whether primary or secondary. But there was no evidence upon which Dr. Brown could ground this cross-contamination. The fact that the officer concerned, Keynes, might have, I think that is the highest he could have put it, might have contaminated the appellant. And the Court of Appeal did find that when he took the swabs off the appellant fingernails, that he had on gloves. So, we are respectfully submitting that the fresh evidence is not admissible. Ought not to be admitted because it is neither credible, and in the case of Syndicum Court, her conclusions are based on evidence for which application have been made for the evidence to be admitted, and that is indeed fresh evidence, and it's tainted by the fact that there are sisters of the appellant who at the 12th hour are seeking to advance his appeal before your lordships. That's all I had, unless there is anything more that both wishes to say.
There appear to be no questions. Thank you very much indeed. Mr. Hamilton, thank you.
My lady, could I respond shortly? So my learned friend takes issue with Dr. Syndicum Court, not on the basis of expertise or of prejudice because of late service and unavailability of his own expert, but because purely he says that her report is based on the incredible statements of Bonalyn and Elena. Well, my lady and my lord, I would say that's simply wrong, factually. Dr. Syndicum Court's report does specifically deal with, even on Keynes's case. Secondly, is that my learned friend says that the court has a discretion to refuse to admit the evidence. Well, my lady, could I take my lady and my lords to page 1223 in the authorities bundle, which is page 48 and 49 of the Eastern Caribbean Supreme Court Act. And I'm referring at this stage to purely to Dr. Syndicum Court. Section 48 says, for the purposes of the appeal, the court, if it thinks necessary or expedient in the interests of justice, exercise the powers below, and then duty to admit fresh evidence. Without prejudice to the generality of Section 48, the court shall, unless it is satisfied that the evidence, if received, would not afford a ground for allowing the appeal, exercise its power under that section if it appears that the evidence is likely to be credible. And there's no suggestion that Dr. Syndicum Court is not credible. Would have been admissible at trial, clearly would have been as an expert on an issue which was central to the case, and is satisfied it was not adduced at trial, which it wasn't, and there's a reasonable explanation for the failure to adduce it. Now, my lady, my lords, in all...
There seemed, my apologies, there seemed to have been a misunderstanding. I never said the court had the discretion to refuse to admit the evidence. I said the court has a discretion to admit the evidence.
Yes.
It's
a non-point.
It's a non-point.
I mean, clearly, there's a duty in certain circumstances. But what you would say is, even if you don't get over the hurdles in A and B, there's still a discretion.
Well,
there's a general discretion under Section 40.
Under interests of justice.
If it's in the interest of justice. So,
my lord...
But this is covered by numerous authorities as to the approach to...
My lord, forgive me, it's nonetheless an extremely important point in my respectful submission, because in terms of Dr. Syndicum Court, in order to refuse to admit the evidence, the board would need to find that it's not credible, it's not admissible, and it couldn't have been adduced at trial, and there's no reasonable explanation for it. And that's why it's crucial, and that's why I reject, with respect, my learned friend's submission.
You're making the point that even if we don't regard the sister's evidence as credible, we should look at the expert's evidence in its own right.
Absolutely, absolutely. My lady, my lords, just finally, in terms of the point that I raised and my learned friend responded to about perhaps giving the appellant some, looking at his inconsistencies in a more generous spirit than one would do otherwise, and the fact that he was had recently been drugged with Valium. My learned friend says he was able to give a thorough account of his activities earlier that day. Well, of course, that was when he hadn't been subject to Valium. What he's being asked to recall now is at 9 o'clock, he was given Valium, and at 10:25, Inspector Keynes came in. Or around 9 o'clock, he went to the hospital, I'm sorry. So it's a very discrete point. But in any event, our original submission is that the core of the evidence remains untouched. My lady, my lords, unless I can assist you any further, those are my submissions.
Thank you, Mr. Taylor. Well, we will rise to consider your application. Mr. Taylor, notwithstanding the attractiveness of your submissions, the board has come to the conclusion that the evidence sought to be adduced should not be admitted. You have permission to appeal on grounds 2, 3 and 4, so we would like to hear your submissions on those, please.
My lady, yes, thank you. Bad character, paragraphs 77 to 82 of my case, at page 1056. There are 3 bases on which this ground is brought. The first is that the evidence is simply inadmissible. The second is, if it is admissible, it was used by the prosecution for impermissible purposes. And the third is, again, if admissible, the judge failed to direct the jury properly on the correct approach. The bad character itself, bad character evidence, is set out at paragraphs 86 to 88. And unless my lady or my lords invites me to do so, I wasn't planning on taking you through it. In terms of the inadmissibility base, there are 3 propositions. The general principle, which is the well-known a statement of Lord Heschel in Macon, and that's I've extracted that at paragraph 111 at page 1063. Prosecution is not competent to produce evidence tending to show that the accused has been guilty of criminal acts other than those covered by the indictment, for the purpose of leading to the conclusion that the accused is a person likely from his conduct or character to have committed the offence for which he's being tried, and it's that has been referred to as the forbidden chain of reasoning, and if it's merely adduced to show that the appellant has a propensity to behave badly, then it's inadmissible. If it falls within one of the recognised exceptions, of which there are a number, then it would be admitting, notwithstanding that the impact would be as suggested above, although the judge would have to direct them accordingly. The starting point is, in considering the admissibility, and whether it's relevant to the issues, is the prosecution and defence case. And I summarise these in 2 sentences at paragraph 117 at 1065. Prosecution case was the appellant stabbed the deceased to death. The defence case was one of denial/alibi. Consequently, the central issue was the identity of the assailant. There was no sort of dispute on whether it was a murder. It was a question of who did it. And the jury were also aware, and I set this out at paragraph 122 at 1066, that there was uncontested background evidence relating to the state of the marriage. The deceased decided that she did not want the appellant back. Her mother-in-law had called the police when he attended their home. The deceased petitioned for divorce. They lived separately, and apart from an attempt to speak to her 3 weeks earlier in a car park, which he said almost got him into trouble and resulted in her reporting him to his employers, they had not seen each other for 3 months. The purpose of introducing the bad character in this case cannot be interpreted from an application. There was no application to adduce it. So the purpose wasn't stated. There was no objection by defence counsel. There was no ruling by the judge or discussion before summing up to identify what issues the bad character evidence went to. And we submit that in the absence of that, the only way to determine what the purpose was of admitting this evidence, of adducing this evidence, is to analyse the way in which the prosecution counsel at trial sought to rely on it in the opening and closing speeches. And the conclusion we submit is clearly that it was for the impermissible purpose of demonstrating the propensity of the appellant to inflict violence against the deceased. My lady,
so is it propensity to inflict violence generally, or is it propensity to inflict violence on this victim?
My lord, I hesitate because it's not completely clear. And I say that because at one stage the prosecution counsel talks about his helpless inability to control himself, and that could have been in general terms, control his temper. And indeed, one of the grounds I say in relation to prosecution counsel's impropriety is that he puts to the witness Aquila Rawlings, "Are you afraid of him?" So whilst the central part of the prosecution's use of it is to against violence against the deceased, it does seem to be a slightly wider scattergun approach of someone who is a violent person.
Well, what's the law? Is it admissible in a case where somebody is accused of killing somebody else to prove that there was hostility between them?
My lord, it depends on the details. Clearly, in the case of Ball, it was a question in the course of argument that his lordship said, I think he asked, isn't it possible for evidence of enmity between the deceased and the person, the defendant, admissible to show that?
It's in the authorities at 1304, and that's exactly what was said. But I mean, what's your submission, Mr. Taylor?
Well, my submission is
in the ordinary case, if the question is who killed X, and you can prove that Y disliked X and had threatened X before, and indeed had used violence to X before, are you allowed to do it or are you not?
Well, my lord, with respect, it's the threatened before that would have to be analysed. It depends very much on what the issues are and what the defence case is. If the defence case is, like in a number of the authorities I've quoted, putting forward innocent association, coincidence, then it could be used to rebut that. But to put it in simply to show that was the state of the relationship would not be admissible.
You say not?
No. My lord, I hesitate. I don't mean to be unhelpful, but it is clear from the authorities that there are circumstances where, in the specific facts of the case, the evidence in those circumstances would be admissible, but not simply to show that as the background.
Why can't you show who amongst the whole world had a disposition to harm this particular victim? In other words, it's the television policeman's question. Did she have any enemies?
Well, My Lord, I think the answer falls into two parts. The first is that if the question is, were the jury entitled to know the stormy nature of the marriage, then the answer is yes.
Right.
And that's the part that I set out at the beginning in relation to the uncontested background evidence. As to that, in terms of the acts themselves, and my lord and my ladies, can I take you to page 1065, paragraph 120, and then over the page I set out, taken at its highest, at the top of page 1066, the events that the jury could only be sure about were the following. 3 years before the murder, it could be inferred that he caused swelling to the deceased's arm and wrist. He apologised, cried, and said it wouldn't happen again. 2006, the deceased phoned Yvonne Glasgow crying. She said that Warrington had hit her. He told her to stay out of their affairs and hung up the phone. The next day, she saw an injury to Chamel's ear. 2006 February, following the deceased's car, pulled out the key from the ignition, verbally aggressive to the deceased and Yvonne Glasgow, and blamed the latter for the state of their marriage, apologised to the deceased, asked if she was coming home, and then went to sleep in the car. May 2006, police assisted the deceased in removing property from their home. December 2006, he removed property from the home and was aggressive and unpleasant, and he tried to grab a chain from her neck that he'd given her, aimed a bottle of water at her but didn't throw it. And as the judge said, this was the only direct evidence in relation to some measure of violence. Now, my lord, the difficulty in those circumstances is that it doesn't fall within any of the exceptions. And if the general rule is evidence which goes to show previous bad behaviour is generally inadmissible, it can only be admitted if it is relevant and falls within one of the exceptions. And my lord, that's why I hesitated in answering your lordship, because in all of the cases that I've cited, there are specific reasons over and above the fact that there has been bad relations between the deceased and the defendant. That is not enough. So I suppose the short answer to my lord is no, it's not admissible in those cases, because otherwise in every case in which the husband was accused of killing his wife, they would, or the other way around, the evidence, specific evidence of bad character between them would go in without exception. And it's that part, without exception, that I think one needs to analyse each of the details of the case. And certainly in this case, there was insufficient to pass any of the exception tests. My lord, my lady, can I take you to the transcript? Because I think it's important to see the prosecution case in context. The first matter, the quotes are set out at paragraph 91 of my 1060. If I can take my lady and my lords to the specific pages. Page 36, line 5. The evidence will lead...
Could I have the electronic?
Are these all set out in your
Page
case?
36. It's page 36.
Probably starts at 35, to be fair to you, Mr. Oh, all right, 36, yes.
My lady, I'm, of course, guided by you as to whether you wish me to take you to the transcript or just follow the parts I've extracted in my case.
You wanted to take us to the transcript. You take us to the transcript.
My lady, thank you. So at page 35...
It is 36.
it sets out the background there from page 30, line 13 onwards, and then the main part is page 36, line 5. The evidence will lead that the husband was physically and verbally abusive towards both the mother of the deceased, that seems to be general evidence of violence to others, Audette Weeks, and the accused. workmate and good friend Yvonne Glasgow will speak of their own knowledge of the violence, abuse and humiliation to her meted to Shamel by her husband since their marriage. Her mother will speak of an injury as early as 2003 when she was forced to come to the aid of her daughter. That particular incident took place during the marriage in December 2006. The picture that emerges is that of a husband who has an uncontrollable temper, which comes with abuse, both physical and verbal. And my Lord, as I said to my Lord Hughes, the reason that I hesitated in whether it was put in as general propensity, it's comments like that. And then, my lady, over the page, at page 37, at line 16, a further theory of the prosecution, or rather one of the elements of the prosecution case, is that the deceased has exercised her firm determination to sever the relationship to rid herself legally of her husband. The result in part of that, so we infer, that the deceased conceived the idea, it was as though if I cannot have her, no one can.
Now, is that bad character evidence? In other words, is it within the general prohibition of making?
My Lord, yes.
Is it?
It certainly is, because it's relying on the bad character evidence to make an unfounded speculative theory.
Well, the mother's evidence about the arguments, for example, is, one might have thought, potentially suggestive to a jury of a motive here. One of the fights arises when he pulls a silver chain from her neck because he gave it to her, and if she's rejecting him, he's going to take it back. Another is when he and a friend go around to dig up the clothes pole in the garden, because he's not going to allow her to retain the clothes pole if she's rejecting him, and so forth. I mean, if that's a picture that's emerging, what's significant isn't simply the fact that he's a man who easily resorts to the use of his hands, but that it's specifically targeted at his wife because of her rejection of him.
My Lord, with respect, it seems to be a huge leap to move from attempting to remove a chain that he gave her in a clothes pole to the speculative theory was that we infer that the deceased it must be the appellant conceived the idea as if I can't have her, no one can. I mean, it's a huge leap. But
that's simply the prosecutor's opening address to the jury. At the end of the day, they hear the evidence, they draw such inferences from it as they think are right.
My Lord,
may or may not be any good, Mr. Taylor, but it's not bad character, is it?
Well, my Lord, it's impermissible because it's clearly based on bad character.
Ah, well, that's, well, all right, let's see.
That may not have been what I said, but that's certainly my submission.
So this is going to the conduct of the prosecution, which is not what we're on now.
Both, my Lord. It's the purpose for which the prosecution sought to rely on the bad character evidence.
Right. If you've got a jealous spouse, is that or is that not capable of being motive for violence to the other?
Well, my Lord, again, I think one has to look at the detail. A jealous spouse may be someone who says to their husband, you're out every night, I don't like it. Well, that's clearly at one end of the spectrum. The other is where the jealous spouse sells his Ferrari because she thinks he's having an affair. But neither of those would necessarily be the basis for asserting that he then killed her. If one takes the middle ground, which is here, there were arguments, there was a stormy relationship, that simply can't go in because that was part of the background history. The jury were told of the extent to which that the marriage was stormy. But to go on and rely, the very danger that comes from putting in impermissible evidence is that it allows the prosecution to go on and make these assertions, which, with respect, are simply unfounded and speculative.
I'm having some trouble in understanding what principle you're relying on, because this seems to be going beyond what one would call normally bad character evidence, which is about propensity, general propensity. we're talking here about evidence directed to this particular victim, which may show a motive and so on. Now, you have to persuade us that that was so obviously inadmissible, even though no one objected to it at trial, we should say now that it simply shouldn't have been allowed in. But what principle of law would enable us to do that? I don't.
If the board's view, and I would submit this is not what one would infer from this, but if the board's view is that this is not based on evidence of propensity and simply goes to motive, then my answer would be that there are so many other statements relying on the bad character for propensity that would make it impermissible. But, my lord, the prosecution would not be able to put forward this theory if it was a one-off incident. He's clearly relying on the propensity argument in order to make this theory and this speculation.
Well, I wonder if that's right. I mean, you may be right about what was happening here, but I just wonder if it's right that a single incident would never be admissible.
My lord, again, it depends on the
In the previous week, it might be very relevant, mightn't it?
My lord, it may be admissible, for example, where in one of the authorities the charge is threats to kill, and there was evidence of previous threats to kill.
Well, clearly.
One can,
That one's easy.
it's unarguable.
But no, I mean, supposing you've simply got a spouse found dead, and the person charged is the other spouse, is it relevant to prove that they had a terrible row the previous week? Must be.
My lord, the previous week is very different to...
No, I understand that.
But that's why I say it's the detail here that there's simply none of those factors that would fit in with either similar fact or motive or other things. And that
Your case is that really that nobody thought about making or how it was to be put at all. They simply steamroll it ahead as if they were doing a defended divorce.
and was not corrected or regulated by the judge.
Yeah. Okay.
So, my lady, my lords, the submission is propensity. If your lordships find this was not propensity, it was certainly based on the evidence of propensity and shouldn't have gone in. And then at page 38, line 14, in short, the evidence will be relying on to implicate the accused is the prosecution contends that the matter of the fights was a clear mark of violence which the accused had meted out to her. The behaviour of the killer on the night of the 16th was purely consistent with that of the husband accused throughout most of their marriage.
You say that's pure propensity, do you?
My lord, yes.
The woman suffered a violent death. He was a violent man. That's the sort of connection that seems to be made there.
Where was that last quotation?
My lord, I'm so sorry. It's
38, 39, bottom of 38.
38.
That's got it, yes, thank you very much.
My lord, I think that goes back to the point of sort of the general principle, can you put in bad character in a stormy marriage? I don't think that the suggestions of violence and the allegations made by the bad character evidence come anywhere near meeting the threshold of similar fact or other matters which would justify.
I was making the point in your favour.
Yes, my lord, I was hoping
Not similar fact, Mr. Taylor. That's not the point. That's not the windmill you've got to tilt at. The windmill you've got to tilt at is motive.
My lord, yes. I mean, I can deal with that, and perhaps if I can deal with it now, it may... My lord, my lady, it's at page 1065, paragraph 118. And it's also responded to the point made by my learned friend in his case, in the supplementary case at 1193. 1195. Perhaps if I could just at 1065. made the point about the untenable theory, and it's at page 123 that I really deal with. This is very different to a case where it has been accepted as being relevant. And, my lord, the Alan Phillips case, threats to kill, and my Lord Hughes's judgment in Myers and the Queen. And perhaps the answer is in the question that my Lord put at paragraph 47 of the judgment at the bottom of that paragraph. The evidence rebutted the argument, why on earth should this defendant, who has no proven connection with or dispute with the deceased, have taken it into his head to shoot him? Well, my Lord, this is a case in which there was a marriage, and it cannot simply be said that in all cases of marriage where there was a stormy relationship, that that person is going to be a target for the admission of bad character evidence. My Lord, that's where, but my learned friend, I deal with this at 1195 in the supplementary case. My learned friend says, paragraph 20, the evidence showed that the appellant was a person of violent temperament towards the deceased who was capable of expressing contrition in the aftermath of his behaviour. It was necessary for the jury to get some understanding of this personality trait in order to carefully weigh the evidence. Well, my Lord, that really does push it into the area of propensity. My Lord, just continuing with it's now the prosecution's closing speech, which is at page 660. And it really is here that we submit that the purpose of the adducing this evidence crystallises, and it's very clear it was for propensity. Line 5, the fact that there was a history of violence in the relationship does not make him guilty of murder. I want to emphasise that it does not exclude him as a suspect, but it does not make him guilty of murder. The fact that there was a history of violence. It says something, though, about his helpless intonation to beat and seemingly beat bad particular Chamel. It says something too about the strange division in his personality, because he does it, he cries, he says he's sorry, he doesn't know what has come over him, that is the evidence, yet he does it again and again.
It's presumably inclination, is it?
Yes.
Must be, mustn't it? Yeah.
Yes. And then finally, page 695. At line 14, he has this history under which by itself cannot make him guilty. He has his presence at the crime scene, and then he goes on. But the prosecution's warnings to the jury that this cannot make him guilty of murder, in our submission, were simply inadequate and inappropriate for the prosecution to make, and not the judge, or the prosecution alone to make, particularly when the prosecution set out in immense detail the purposes for which they say it is relevant. And my lord, finally, and my lady, finally, the summing up and the way that the judge dealt with it. Page 819. They have given you a lot of, page 15, line 15. They have given you also a lot of background to the relationship between the accused and the deceased. That is not relevant to the offence as to convincing you so that you feel sure he committed it. Well, with great respect to the judge, the jury may well have been thinking, well, what is it relevant to? And gone on to use it for whatever purpose they thought appropriate, however impermissible.
What should she have said, Mr. Taylor?
My lord, that must be on the basis with respect to it's admissible.
I was going to say, it shouldn't have been there, so she shouldn't have said anything.
You say no, that should have been in.
If it was admissible, then I deal with that at paragraph, page 1071, paragraph 143 onwards, and at 146, it was inadequate and helpful. It didn't warn the jury as to what use they could use it for and what they shouldn't use it for. And at 148, we set out the directions that she should have given, the relevance, the fact that just because he'd acted violently previously did not mean he was guilty of the offence. So to avoid the propensity inference, the difference between the offences alleged and the murder, and correct the prosecution. I think correcting the prosecution was clearly vital, but to not correct the prosecution, not to give a direction, and to leave it open that it's not relevant, the jury would have really seen to use it as they saw fit, which would have been at the risk of impermissibility. Forgive me, my lady. My lord, my lady, I'm very happy to expand on the responding to the matters that my learned friends have raised in their cases, if I can put it this, not disrespectfully, their post-trial justifications.
Extremely disrespectful, but of course it may be justified or accurate.
Well, I apologise if it is. It wasn't intended. But, my lady, the submission I make in this in regard to those is that if the board accepts that the jury were told by the prosecution that the purpose they can use this material for is propensity, it makes no difference at all to the damage that will be caused if my learned friends now say, well, actually, it could be used for this whole range of other things and they justify its admission. None of those were relied on by the prosecution. Could I take, my lady and my lords, to one authority, and that's my Lord Hughes's judgment in Myers and the Queen, and the authorities bundle, page 1767. There's two parts of my Lord's judgment that I refer the board to, which I say are particularly applicable here, and they're warnings as to the use of this evidence. And the first is paragraph 41. On page 1785. And this goes back to our first point, that there's a general exclusionary rule and any exception has to be justified. And it does not exist, my Lord Hughes says, does not exist in the evidence which is admitted not normally to be restricted to that which is within the justification. The justification is the measure of the admissibility. The existence of such justification does not generally create open season to adduce any evidence of the defendant's bad character or misbehaviour. And, my lords, we say we don't even get to that stage because it's clearly propensity. The fact that it may be that some of it was used to go to motive was clearly based on that impermissible matter. And then finally, paragraph 52, in terms of putting it in as part of the background, relying on Petman. My Lord Hughes says, Petman proposition that it's matters which go to the background that the jury wouldn't be able to understand otherwise. It needs cautious handling if it's not to become a token exercise for admitting the inadmissible. Claims by prosecutors that the evidence is necessary to the understanding of the case, or as is sometimes asserted, to discourage the jury from wondering about the context in which the events discussed occurred, need to be scrutinised with care. It is only where the evidence truly adds something beyond mere propensity, which may assist the jury to resolve one or more issues in the case, or it is the unavoidable incidence of admissible material, as distinct from interesting background or context, that the justification exists for overriding the normal making prohibition on proof of bad behaviour. My lady, my lords, the proposition for which we say that quote is support is that once the jury have been told of the appellant's propensity of violence, it's simply not acceptable to then look for other reasons that it may have been admissible when clearly it wasn't relied on for those purposes, and more importantly, the jury weren't told as to how they could use it.
But the way it's put at paragraph 47 is interesting, where His Lordship said that, putting it another way, the evidence in the cases rebutted the argument. Why on earth should this defendant have taken it into his head to shoot the deceased? And equally, one might say that in this case, if a jury are wondering, well, why on earth would this man have killed his wife? The obvious answer on the evidence that was led is because he is very angry about the fact that she has left him.
My lord, the difficulty with respect with that approach is that, first of all, the jury had an admissible context in which they could consider the difficulties. It's not as if they simply didn't know the marriage was a stormy one. They were aware of that. It's not as if the appellant was saying, I was in a very happy marriage, and that would have misled the jury. They were aware that divorce proceedings were pending. They were aware that he'd moved out. They were aware of a number of matters for which they could place it in that context and indeed answer the question, my lord's question, why on earth should this defendant be the victim, be the assailant? But my lord, the difficulty is it goes so much further. The prosecution are putting him forward as someone who has an uncontrollable temper. It moves it straight from the facts of the bad character evidence, which I outlined as to the highest that it could be taken by the jury, to someone for whom he has no ability to control himself. Not only does he have no ability to control himself, but he also has a reason. If I can't have her, no one else will. And so it puts together a completely impermissible theory based on impermissible evidence. And it wasn't necessary for the jury to be aware of that simply to understand. My lady, my lords, I am, as I say, very happy to take and expand upon the matters in our case relating to rebuttal of the defence, similar fact, and other matters. But I hope I've dealt with them in the submissions. And unless I can assist you further, those are my submissions on that ground.
Could I just ask one question? Do we have the agreed statement of background that was put to the court? You say they had the information about the stormy marriage and so on. Where do I find that in the transcript?
My lord, it's taken from evidence that was placed before the jury. Perhaps I can deal with it this way. My lord, in page 1194, this is in effect our response to the respondent's case of it's the supplementary case. And it's paragraph 18. It sets out there the references to the evidence that was uncontested and that the jury could have been sure of those matters.
Yes, so it wasn't a written statement. It came from the accused's or the appellant's interview with the police.
And other witnesses. I think one of the police officers said he obtained the divorce petition from
Yes,
the
Corporal
registrar.
Keynes gave evidence that he divorce petition.
Yes.
Yes.
I mean, you're clearly right that there wasn't a dispute that the marriage was stormy, but that was because the evidence of Mother and Miss Glasgow wasn't substantially challenged. But without that evidence, was there any other, as it were, any other admission or evidence that this was as you say, a stormy marriage? That it was on the verge of divorce? Yes.
My Lord, sorry, could I just take a moment?
They were in dispute, you see, that's the point.
Yes.
He didn't give evidence. There weren't any agreed facts or admissions.
It's just from the way you spoke, I imagined there had been some agreed admissions, but certainly what you've pointed to in 1194, paragraph 18, doesn't begin to amount to an agreement that there had been a stormy and turbulent marriage. And the fact that they were getting divorced doesn't give rise to that inference either.
Not at all, no. Could I also take issue with your use of the word stormy? Stormy tends to imply that both parties are responsible for violence and rows and so on. I'm not aware of any evidence in this case of anything done by the deceased which could amount to provocation or in any way suggesting that she
My lady,
was
I accept that
argumentative,
completely.
rowdy, or whatever.
I accept it completely. I apologise and withdraw that term. What I can say is that in the appellant's latest affidavit, he sets out an account which suggests otherwise, but I accept entirely that that was not the state of the evidence at trial and it wasn't challenged in that form.
Well, Mr. Taylor, would that be a convenient
My lady,
moment?
yes. The other matters I think I can take far more
I am suggesting that we might adjourn, given the state of the clock. And that would give you time to consider whether you wish to raise any of the other matters. We'll look forward to hearing from you again at 2:00.